Good day, my name is Barrister Kelvin. I offer legal advice that make you informed in law. I educate you about civil laws governing the state. Today I would be talking on corporate criminal liability. Here's a clear, structured way to advise your client on corporate criminal liability and their personal liability, especially in a Nigerian law context. 1. Meaning of corporate criminal liability. Corporate criminal liability means that a company, as a legal/artificial person, can be held criminally responsible for offenses committed in the course of its business. Although a company is not human, the law treats it as a person capable of committing offense, being prosecuted, being punished, usually by fines, sanctions, or dissolution. 2. How a company commits a crime. A company acts through human beings. Liability arises through a doctrine of identification, directing mind theory. The acts and intentions of key officers are treated as the acts of the company. Examples of such persons: directors, managing directors, senior managers. If they commit a crime within their authority, the company is liable. B. Vicarious liability. The company may be liable for acts of employees done in the course of employment for the benefit of the company, even if the company did not directly authorize it. C. Statutory liability. Some laws specifically impose liability on companies. Examples in Nigeria include environmental laws, financial crimes laws, corporate regulations. 3. Types of offenses a company can commit. A company can be liable for fraud, environmental pollution, tax evasion, regulatory breaches, negligence-based offenses. However, traditionally, offenses requiring personal intent like murder are difficult to attribute, though modern law sometimes allows it in certain contexts. 4. Punishment of a company's ends. A company cannot be imprisoned. Penalties include finesse, compensation, forfeiture of assets, revocation of license, winding up in extreme cases. 5. Personal liability of your client. No. Advise your client carefully here. This is critical. A company does not always shield individuals. Your client may be personally liable if a direct participation. If your client personally committed the offense or took part in it, they will be individually liable. B. Consent or connivance. If your client approved the illegal act, turned a blind eye, they can be prosecuted alongside the company. C. Negligence or failure to act. If your client is a director or officer and failed to prevent the offense, failed to ensure compliance, they may be liable under statutes. D. Statutory provisions. Many Nigerian laws state where an offense is committed by a company, every director, manager, secretary, or officer who consented or was negligent shall also be liable. 6. Possible defenses available to your client. Advise your client to rely on due diligence defense. They took all reasonable steps to prevent the offense. Lack of knowledge. They were unaware and had no reason to know. Act outside authority. Employee acted outside scope of employment. 7. Practical advice to your client. That you can conclude your advice like this: ensure strict compliance systems are in place, keep proper records and internal controls, avoid approving suspicious transactions, act immediately if wrongdoing is discovered, take legal guidance before major decisions. 8. Simple conclusion. For your client, the company can be criminally liable as a legal persona. The client may also be personally liable if you were involved, negligent, or aware the law does not allow hiding behind the company to escape criminal responsibility.